court agree with me that no, that an oral application cannot fly. In as much as I am opposing, the prosecution is opposing.
Right.
Then the defense counsel, I'm on record, the defense counsel started indicting the person, the integrity of the judge.
Wow.
In open court.
Wow.
Started indicting the integrity of the judge in open court. I didn't say a word.
You learn anybody. If you don't do my jassy, that's why I am. You understand? About Jomo Yami. About the Joro don't go where I want to for your Jazz. It's your back in simple to don't compare on any can. The Madrotier. You got about the just the radar. One man shall I have go along. So, my pay number one like pay, inshallah. My number one I pay, but go along. Mister.
Hello, sir.
Assalamu alaikum.
Alaikum salam.
My barrister. So,
yes, sir.
ẹ ṣeun gan, ẹ kú farada. Gẹ́gẹ́ bí a ti ṣe jọ mọ̀ tí mo dẹ̀ ti sọ fún wa pé pẹ̀lú ògo Ọlọ́run yóò wù mí kí a bá àwọn èèyàn wa sọ̀rọ̀ lórí tó kọrin tó ṣẹlẹ̀ níjọ́ Thursday nílé ẹjọ́ lórí ọ̀rọ̀ ẹjọ́ captain. Mo bẹ́ẹ̀ ń gbọ́ mi dáadáa sà.
Loud and clear, sir.
Mashallah. Now, àkọ́kọ́ yóò wù mí kí a bá mi kọ́kọ́ introduce ara yín kọ́mọ ẹni tó ń sọ̀rọ̀ bó tilẹ̀ jẹ́ pé ọ̀pọ̀lọpọ̀ wọn náà ti mọ ohun yín tẹ́lẹ̀. Ṣùgbọ́n yóò wù mí kí a introduce ara yín sà. Then ẹ wá ṣàlàyé fún wa tó ṣẹlẹ̀ káà tó wá béèrè àwọn ìbéèrè lórí tá à ń gbọ́n tà lọ́wọ́ yín sà. So bismillah.
Okay, sir. My name is Oladayo Ogungbe. I am the managing partner of Ogungbe and Ogungbe Attorneys.
Mashallah.
And I have the fiat of the Attorney General to prosecute in Federal Republic of Nigeria versus Mohammed Yahya and 6 others.
Now.
So, now, with respect to what happened on Thursday, okay, let me just give a summary of what transpired in court.
Sir.
Prior before the proceedings on Thursday, the defense counsel has filed multiple applications, series of applications. Okay, let me lay the background. The first thing, why the matter was initially assigned to Justice Owebo.
Okay.
As at the time the matter was before Justice Owebo,
okay,
the defendant refused to come. They complained of service. Unfortunately for the defendant, a senior advocate of Nigeria appeared for them while they were absent.
Wow.
So Justice Owebo was in shock that you alleged that you were not served, but you, a senior advocate of Nigeria, appeared in a matter for a defendant that were not served. So Justice Owebo was not ready to listen to that line of thought because obviously he saw that this one, though they don't appear to be serious. So he insisted, he gave an order that the defendant must appear. So as a result of that, they filed a series of, but they wrote a petition against Justice Owebo.
Wow.
The admin judge, that's the Chief Judge of Federal High Court, Justice So. That one reviewed the petition. Of course, they indicted the person of Justice Owebo. As at that time, we have not even been granted the fiat of the Attorney General to come in, but we've been going to court as the nominal complainant lawyer, which is, as we were appearing as a watching brief, which is allowed in the normal criminal proceedings. Now, when the Chief Judge considered the application, the petition they wrote against Justice Owebo, the Chief Judge realized that the petition does not have merit. There is no factual evidence or material evidence to substantiate whatever claim they are making against the Honorable Justice.
Right.
So can you hear me?
Yes, I can hear you.
Can you hear me, sir?
Yes, sir. I can hear you. Yes, sir.
Okay, so the Chief Judge now dismissed the petition. So usually what was supposed to happen is that if the Chief Judge considered the petition meritorious, the Chief Judge will write to the sitting judge, the presiding judge, and call for the case file and reassign it to another judge. But because there are no material evidence in whatever allegation they had leveled against Justice Owebo, so the petition was dismissed, and Justice Owebo was ordered to continue to hear the matter. So it was in the process of that.
Yes, sir.
Justice Owebo was now transferred because at that time they usually do reshuffle. They reshuffle some of those judges. They transfer them from one state to another. It's a federal high court, so they can transfer you from Lagos to Ogun State to Akwa Ibom to Kano. So they transfer some of those judges. So Justice Owebo was one of those people they transferred.
Right.
So what that means is that another judge we assume presiding over the matter afresh.
Right.
In law we call it the matter will now start de novo. De novo means it will start afresh. However, the new judge will be guided by the proceedings that has transpired, because they will give him all the files and everything. So the matter was eventually assigned to Honorable Justice Dipeolu.
Right.
Now, so Dipeolu has been handling the matter. When we now got the fiat from the Attorney General of the Federation's office to prosecute after we realized that the police had been compromised.
Right.
And the defense counsel, the defendants have been making effort to threaten the officers of the Ministry of Justice that took over the case from the police. They were writing a series of petitions against those ones. So I then advised my clients that there is need for us to, no matter how rigorous it is, we should apply to the office of the Attorney General, lay the facts bare before the Attorney General, and request that it be granted to us for us to prosecute the matter.
Right.
And we made all available evidence before the office of the Attorney General, and the Attorney General considered our application, called the officers from the Federal Ministry of Justice that was handling the matter, asking some few questions. That one was able to corroborate the fact that it appears the defendants are all out to tarnish his own image because he wrote petition against some of his directors and all of that. So we said, okay, we don't want to throw you under the bus. We know the people we are dealing with. Give us the fiat.
Right.
So the Attorney General reviewed our application and granted us fiat
Mashallah.
to prosecute the matter. So that was when the fiat was personally granted to me, and I came into the matter fully as a prosecutor. At least plus or minus, I have over 13 years experience as a lawyer, both in civil and criminal matters. So I understand all of these gimmicks. So when we came into the matter, Justice Dipelu realizes that, that's the learned justice, realizes that these people have not appeared. The defendants have not appeared for once. But there have been series of counsel representation. And their game plan has always been, we're not served. And the judge was like, come, I have been a prosecutor before I became a judge. I was a prosecutor for about 20-something years before I became a judge. You cannot be appearing and be telling me the defendant has not been served. This is a criminal proceedings. In fact, there is before me affidavit of service by the bailiff of the court. So how can you now tell me you have not been served? So the main series of arguments, we also made several submissions before the court. It was pursuant to that. We applied for bench warrants.
That's it.
Because the implication of a defendant failing to appear in a criminal proceedings, even after he has been served, even if he's aware that a criminal proceedings has been commenced against him,
right,
it becomes even worse if a lawyer appeared for him in the same criminal proceedings. So you cannot feign ignorance of non-service.
Wow.
Once a lawyer appears for you, you are deemed to have knowledge of the criminal proceedings. Come and take your plea.
Exactly.
So if you have anything, then you can challenge the court. So it was pursuant to that, with respect to, so we drew the attention of the court to a number of provisions in the Administration of Criminal Justice Act 2015 that empowers the judge to issue a bench warrant against a defendant or a recalcitrant defendant that failed to appear in court. So it was pursuant to that the court issued a bench warrant against the defendant last year. So the moment they saw the bench warrant, they filed several applications. One of those applications, which is critical to Thursday's proceedings, was that they now challenge they said, according to them, they have lost confidence in the judge.
Wow.
To continue to preside over the case.
The second judge.
The second judge.
Wow.
That's for the second time. Now, in this case, they were clever by half to have not, if they had written a similar petition to the chief judge,
right,
against the judge, the petition would have equally been dismissed. So what they did was, rather than write a similar petition like they did before Owebo to the chief judge, they now filed an application before the same judge, whether the judge will disqualify himself.
Wow.
Now the implication of that is this: before a lawyer can do that, because we are trained legal practitioners,
right?
We have rules, we have ethics,
right?
Before a lawyer can file an application before a judge to disqualify himself, that they don't have confidence in the judge again, what it means is that you are saying the judge is biased.
Oh, wow.
Unfortunately, the judge is saying, your defendant has not even appeared before me.
Not even for once.
Not even for once. I don't even know them from Adam.
Allah.
You are filing this kind of application. Are you joking?
Yeah, seriously?
Before I can even consider your application at all, the defendant must appear before me.
Exactly.
If you now say I am biased, no problem. I don't know the prosecution. I don't know you, the defendant. I don't care if you are a senior advocate. Let the defendant appear first. If the defendant appeared before me, then I will answer for your case. I will consider your application, even though we filed a counter affidavit. We oppose that motion because part of our own argument is that it has become their stock in trade,
right,
to indict every judge. Now, the tactic is that they don't want the matter to go on, but they can only try. They can try. Unfortunately, these tactics they are using can only last but for a while. because every judge will now start paying attention to that case.
Exactly.
And unfortunately, they are giving themselves a bad name.
Definitely, yes, sir.
Now, and because you can't indict the person of a judge except you have concrete evidence that the judge is biased. Even Yaya Bello, a judge issued a bench warrant against him for failing to appear to take his plea.
Wow.
So every lawyer knows that if there is a criminal charge, if a criminal charge has been filed against you, and a proceeding is ongoing, and you fail to appear in that matter, the provisions of the law is clear because we issue a bench warrant for you to be arrested.
Exactly.
So it is common sense. Even a lawyer, the law school student that just graduated, just yesterday or 2 days ago, they know all these things.
Exactly.
They will issue a bench warrant against you. Now, so eventually, when the argument went back and forth, we were able to apprehend what's his name, Captain.
Yes. Alhamdulillah.
So now let me streamline it down to what transpired on Thursday.
Now,
so Captain was brought before the court.
Yeah.
We informed the court that we have an amended charge because since we are only able to arrest one of the defendants. The law requires that we amend our charge to reflect his name so that he can take his plea so that we can start with him. Then if we are able to arrest other defendants in the course of the proceedings, we will continue to amend our charge.
Exactly.
So as it stands now, we still have a valid bench warrant to arrest any of them. I'm going to explain the implication.
Okay.
Now, so the moment immediately we arrested Captain, we took him before the court. We informed the court that we have a charge before the court, an amended charge. Then I sought the leave of the court by way of application that the court should accept the charge and read the charge for the defendant to take his plea. The defense counsel raised an objection. They argue endlessly that the charge, I didn't file a motion, I didn't file this, I didn't file that. Well, I have to draw the attention of the court to several decisions of the Supreme Court. In fact, in the decision of the Supreme Court, they cited, he even supported my own case.
Wow.
So I cited a number of decisions of the court with respect to the fact that no, in an amended charge, in the criminal proceedings, you are allowed, the prosecution is allowed to apply orally before the court or leave of the court to accept the charge and read it before the hearing and read it to the defendant for the defendant to take his plea. The court took argument of both of us and the court delivered a well-considered ruling.
Wow.
And the court ruled in our favor that I have done the proper thing. And the court cited a number of authorities to that. And the court now informed the registrar to read the charge to Captain for Captain to take his plea. So the charge was read to Captain and he took his plea. And he pleaded not guilty.
Okay, Captain pleaded no guilty on Thursday.
Yes, he pleaded not guilty. So meaning the case has started officially.
MashaAllah.
Meaning, I repeat, meaning the case has started officially. Because by the record of the court, Captain has taken his plea. Now the next stage was then the defense counsel, that's the senior, the Lennon Sikh, applied for Captain's bail orally.
Okay.
And I opposed it because I told the court, I am barely 13 years post-score. I am relatively young. But in my 13 years post-score as a lawyer, I have never seen where oral application is made at the Federal High Court or State High Court to apply for bail application. I may be wrong, but that was the position I put before the court. And I told the court that the reason why this oral application for bail will not fly is because this particular defendant is considered a flight risk. Because we have been looking for him and others for close to 2.5 years or 3 years. So therefore, I am going to be opposing an oral application. Then I informed the court that we need to, that the defense counsel should be compelled to file a formal application so that we are going to have the opportunity to respond to the formal application and put before the court material evidence to show that this defendant is a flight risk. Even if the court is going to admit him on bail, they should admit him on bail in such a stringent condition. Since it is a bailable offense.
Definitely.
But he is a flight risk. We went back and forth on it, then the Lennon Sikh, that the defense counsel now started indicting, because the court agree with me that no, that an oral application cannot fly. In as much as I am opposing, the prosecution is opposing. Then the defense counsel, I'm on record, the defense counsel started indicting the person, the integrity of the judge.
Wow.
in open court.
Wow.
Started indicting the integrity of the judge in open court. I didn't say a word.
Wow.
We were now reminding the court that they have an application that is challenging the integrity of the court, that the court should disqualify itself. The court refused to take it, blah, blah, indicting the personality of the judge. Why the defense counsel was doing that? The defense counsel was not telling the judge that the judge should release captain to him.
Okay.
Then when they will perfect his way, that was when I flare up.
Exactly.
I got up and I told the court that I am opposing that application. That the defense counsel have been going on and on, indicting the integrity of the court, indicting my own integrity. Now, the same defense counsel is asking the court to release the defendant to him with another application. I said I don't trust the integrity of the defense counsel either. So the court, because at that point I got flare up, because the reason why I reacted the way I reacted is because that is not the way we are trained in law school. That is not the way we are trained as a lawyer.
Exactly.
What happened on Thursday is an eyesore. Because we as a junior counsel, we are supposed to be learning. But what I saw that day, I stood up and I lost it, because I was supposed to learn from our senior. But when your senior conduct is such that leaves much to be desired. At that point, people, the lawyers in the court were like, what kind of... So at that point, I just felt like, no, this thing has gone beyond. This thing is now personal.
Right.
As if they have, I don't know, as if they have anything against the judge before now. In fact, the judge had to say in open court that, I'm seeing this defendant for the first time. I don't even know you.
Exactly.
What kind of indictment is this? Okay, no problem. When the court saw that, the way they were going, they were trying to draw some inference. And the court was like, hey. Then the court refused the application. Listen, the court delivered a bench ruling that they should go and file a formal bail application.
That's it. Formally.
While I filed a counter. The court delivered that ruling.
Wow.
Then the court now referred to their motion. The same motion where they were asking the court to disqualify himself. The court now made an alluded to the fact that though he doesn't have interest in this matter, in view of the application of the defendant, asking him to disqualify himself, he's going to recuse himself from this case.
Wow.
He's going to send the file to admin judge for the assignment.
Wow.
So that it will not appear as if he has interest in the case.
Exactly.
Because they made that allusion in open court that the court is behaving as if he has interest in the case.
Wow.
Unfortunately, that was the first time. Captain's case. This case is the first case I'll be appearing before the court. I've never even appeared in his court before now.
Wow.
I don't even know him.
Exactly.
So, well, the court has to protect his own integrity.
Definitely.
So say, is there more to this case than... Why are people afraid of doing your trial?
Exactly.
Truly, only because what they were shouting in open court is, police is not the investigation. Police is not the investigation. Go into trial now. Okay, so the court now said, that was how the court said, he's going to send the file to admin judge.
Right.
To admin judge for the assignment. Now, the court now ended it there. At that point, I needed to get guidance as to where captain will be.
Right.
But the court, in all the drama they were doing, the court, I think, just had pity on captain.
Okay.
Because usually, if something like this happens, and the court recuse himself, the normal order the court will issue is that captain will be remanded in prison.
Definitely.
Why the matter will now be reassigned to another judge.
Okay.
Because captain has taken his plea before the court. So I stood up and I told the court that in view of this ruling, my lord, we want to apply that captain be remanded in correctional center pending the reassignment.
Right.
So the defense counsel stood up and said that the court should release him to him. that the court should release him to him. He's going to produce him. He's going to do this. The court looked at both of us. The court laughed. I'm sure what is going in the mind of the court is, if I'm supposed to do what I'm supposed to do, this defendant will go back to prison where we get reassignment. So the court now said, Mr. Ogungbe, what I'm going to do is that I will release the defendant to the learner sick.
Okay.
To the defense counsel. Let me release it to him.
Right.
When the matter is reassigned, he will produce him before the new judge. However, the court now made an order that the learner sick should write a letter of undertaking.
Okay.
And put us in copy that he is taking custody of captain and he will produce him before, once the matter is reassigned to another court.
Mashallah.
The court made that order in open court and the learner said that is not a problem. Up till now, I am here to receive the undertaking.
Wow.
I'm sure the court is here to receive an undertaking.
Okay.
Do you understand?
Yeah.
So until I receive the undertaking, I take it that Captain is still in custody.
Right.
Because the judge will have to release him. But I am here to be put in copy. I am here to be served with their letter of undertaking.
Wow.
So now, the next stage is that we are going to get process the reassignment of the case as soon as that one is not a problem. They will assign him before another judge.
Okay.
So anybody who is deceiving himself or herself that the case is dead, it's just, let me put it this way in Yoruba. Now, you know why I'm happy? I am happy because there is already a checkered history with respect to this case.
Right.
So another judge that is sitting over this case, we see the pattern.
That's true.
We see the pattern.
Definitely.
And he will be ready.
Right.
He will see the pattern. So let them continue. As long as I will never do anything that is outside the purview of the law.
Right.
Everything we have done is provided for under our enabling criminal jurisprudence.
Right.
That's why you don't need to go and hire anybody before you can make your case. Just, it is very simple. It is written in black and white.
Yeah, exactly.
It's either you do what is in the law. So if anybody is saying it is a frivolous case, it is a dead case, the case is dead, see, me, like you know me, sir.
Yes, sir.
I don't listen to some of these.
Of course.
So the only thing I will just tell my own client is, we need this, we want to do this, that's all.
Exactly.
The idea of trying to go on like, you call me, Ogumbe, they said the case is dead. I said, please, these people, some of them are stark illiterate.
Exactly. That's what you're
Some of them don't even understand what is going on. They don't understand how it works.
At all.
And if anybody has deceived them that the case is dead, they should be happy. I am not bothered.
Right.
The only thing is that we'll do what is required by law. Take the case before another judge. Continue the case. If they will now appear before another court, let them now say, the case is dead now. Why is it coming before another court again? See, I'm not bothered.
Exactly.
See, let them be celebrating. This case, we'll do it.
Allah,
if it's going to take us 30 years, we'll do it.
Inshallah.
Oh. Except they are ready to settle. They are ready to settle.
Okay.
All this shouting online, if they let them go and get 30 years on this case, we do it.
Allah.
So I won't say more than that.
God bless you, my barrister. God bless you, my awaiting son, inshallah. God bless you. Like I always said, I always speak for you. For you, because when you were talking, a lot of people are, requesting, but most of them does not understand this aspect. Like there are some things that you can't even express in Yoruba when it comes to law.
In Yoruba, that's the problem.
So that is why I ignore those, comments. I just focus on you while you were speaking. Like God bless you, sir. Now I got some questions for you, sir, because according to one of those accused, I'll call him accused or defendants, which name is Yusuf, precisely Yusuf, one of them, right? Yesterday, after the court, there was a guy that came out online on social media, Facebook, precisely. His name Said, right? I don't know, maybe you know him or what. I don't think you know him, right? So he
who is that?
Said, that's his name of the guy, Said Shitu. He came up on social media yesterday, yeah.
I don't think I know him.
Yeah, I don't think so, yeah. He's a famous blogger like that. So he came out because he's in camp of this Yusuf, right? He's one of his friends. Very bosom friend, right? So he came up and started talking about this case of yesterday. When every one of them has, they receive a message, oh, the case has been trashed. Oh, the judge has, evicted himself from the case. He said the case is not even making any sense. That's what he came out to say yesterday. And when he was, doing the program, immediately one of the accused, one of the defendants called in. And that's Yusuf. He called into the program and he was telling the whole world on that program, like, that the case, the judge have realized the case is frivolous. And that is why the judge is evicting himself from the case. He has thrown it out. That's exactly what he was telling everyone yesterday. And I was just laughing when I see the cut out of the video, because I could now watch the live video, but they cut it and sent it to me. And I was just laughing because I understand what is going on. You understand, barrister? So in this aspect, I have a question. The only question I will ask you, my barrister, yesterday when the judge grants the bail of Captain, was Captain handed over? I'm saying this straight now, that was he handed over to the son yesterday and to take him home, or Captain was returned back to the prison?
Okay, so I don't know what transpired before them, but the court said they should release the defendants,
right,
Captain, to the lawyer, the defense counsel. Right. Why the defense counsel should write a letter of undertaking. To write a letter of undertaking to produce the defendants before another judge. Now, this is it. It was never a bail.
Wow.
It was never a bail. What the judge was trying to do is that after the judge has recused himself from the case, the judge is trying to be careful not to put Captain's liberty in jeopardy, because if truly what they have been alleging against the judge is true, what the judge should have done, because if the judge is angry Usually, in circumstances like that, what the judge says, you are indicting my integrity, no problem. The defendant should be remanded in prison pending when the matter will be assigned before another judge, before bail application will be taken. That will have been the normal order that every judge makes in cases like that. But the judge was even lenient because he's looking at them that, and this is what people are doing. If I do what is in my mind, if I follow the normal procedure,
right?
Then you are in prison for more than 6 months.
I know, right?
More than 6 months. I filed the bail application. Now, so that was what happened. Unfortunately, if they are saying somebody is laughing and the judge says that the case is frivolous, you know why I'm pained.
Right.
There is this proverb that says, if education is expensive, try ignorance.
Allahu Akbar. Allahu Akbar. Ignorance is very, very, very free.
whoever is making this assertion, I don't care who he is, he shows their level of intellectual disability for public ridicule.
Allahu Akbar.
Because clearly they were not properly briefed by their lawyers.
Exactly.
Clearly they were not in court. They have no idea what transpired in court.
At all.
So for them to be saying, this is what he just, come on. Hey, don't worry.
Allahu Akbar.
Before the court is going on vacation, before vacation resumes, the matter I promise you, sir.
Yes, sir.
Except I am not Ogumbe.
Allahu Akbar. Allahu Akbar.
Before vacation, all of us are sorrow.
Inshallah. Inshallah.
After vacation, the matter will have been reassigned to another judge.
Inshallah.
So whoever is said, I don't know why they are celebrating. The criminal proceedings is hanging over at the Federal High Court. Federal High Court is nobody's father's house or mother's house.
Allahu Akbar.
They don't care who you are.
Wallahi.
They are using bail warrant against an ex-governor, against a sitting senator,
of course,
against anybody.
Of course.
So who the hell are you?
Allah.
You can't intimidate anybody.
Of course.
Nobody pays their salary.
That's it.
Sorry, we don't pay their salary except the federal government. So
exactly.
If you think it is this thing, in fact, you know why I'm happy? I'm happy that because the next judge that is going to take over this case,
right,
we already have the history.
Yes, definitely.
Of the way the defense has been indicting each and every one of those judges.
Allahu Akbar. It's 2 judges
so
already.
They will be ready. They will be ready.
Of course.
In fact, me, I even want them to continue with this kind of attitude.
Allahu Akbar.
So that conviction will be very easy.
Easy. Wallahi.
It's very, because by the time the judge says that, what are you people doing? Come and do your case, you are indicting my person.
Allah.
Am I the one that filed the charge? Am I the prosecution? If you think they've not, it's a frivolous case, then do try and convince me that it's a frivolous case. But you know the irony. Let me tell you the irony.
Okay.
I'm saying it on air now.
Okay.
You know the irony. Let me tell you how easy this case is.
Okay.
Let me shock you.
Okay.
There is little or nothing police investigation can do to an online defamation in a cyberbullying, because all we need to do is to play it before the court.
Exactly. MashaAllah.
Sure, you want to deny that you're not the one talking?
I know, right?
You know that somebody did episode. Somebody did series of episodes. Those episodes form part of our evidence.
I know, is enough, so, of course.
Which police investigation do we need?
I know, right?
What we need to do is bring projectors to court, bring it before the court.
Very easy.
So the idea of police is not investigating. Wait, will police falsify or doctor what is already in the video evidence?
I know, right? Allah.
So then, if we play you the video, will you say you are not the one on the screen?
Abi?
So I don't see. This case, like I said, it's very simple to prove. It's for me. It's for my own client to give his own evidence. Then we slot in the disc or the flash and play before let the court watch it.
Exactly. Also, that's it.
And the person that did episode 1, episode 2, to episode 24, we pick the part that relevant to him.
That's it.
The part where they were sending themselves messages. Maybe we don't have the evidence. He was the one that gave us the evidence.
Yeah, of course, I swear to God, wallahi.
He gave us the evidence himself.
He provides all evidence that
we didn't even know.
Wallahi.
We didn't even know that he was in communication with Captain.
Of course.
Before Captain did that video.
Definitely.
And when he did the video, they sent it to themselves. He did episode and he displayed everything.
Allahu Akbar. Allahu Akbar.
We have it already. It's part of the evidence we are going to play in court.
Alhamdulillah. MashaAllah. MashaAllah.
So, the way it works is that it's like when somebody is self-indicting himself. That was what happened. It was from that video. Some names were mentioned.
Right.
Some names that were mentioned that participated in all of these things.
Of course.
So it is very clear. It is a visual evidence.
Right.
Play it, let the court see it.
That's it.
So at that point, come and prove your innocence.
That's it. Allah. That's it.
So there's no hard and fast rule about it. I won't say more.
God bless you, my barrister. God bless you. And one last question before you go, because I won't, keep you so long, because I know the state of your health. May Allah give you more strength, inshallah, more good health.
Amen.
The last question is pertaining to the bench warrant.
Yes.
Is it still in effect or not? It's still valid or not?
No, God has set it aside. No, they should give me another where the bench warrant was set aside.
Allahu Akbar.
No, but maybe I don't understand. They should give me, because it is still a substituting order of the court.
Exactly.
So they should give me an order where the bench warrant was set aside. So until there is an order setting it aside, or they've gone to court of appeal, where the court of appeal has not set it aside, it is still a substituting order of the court now.
Allah. MashaAllah. MashaAllah.
Yes, now. Even if the judge died today and they are signing before another judge,
right.
For instance, this judge that recused himself, God forbid, if he passed, and they are saying that order is still subsisting now, except another court set it aside.
Of course. Of course.
But until it is set aside, it is still subsisting.
That means we still have a valid.
Yes, like can be used to arrest any of the defendants, depending when they are signing before another judge.
MashaAllah.
It's still subsisting.
MashaAllah. No matter how many judges change, will be changed from this case, the bench warrant is still valid to arrest anybody at any time.
Let me see how it works.
Right.
Once a court makes an order,
okay,
whether rightly or wrongly, that order is subsisting. We subsist until it is being set aside.
Allah. MashaAllah.
That is the law.
Okay. MashaAllah.
That is the law.
Alhamdulillah.
If you ask any lawyer, just call a lawyer randomly and say, the court issued a bench warrant, but the court did not set it aside. They indicted the court not himself from the case. They are saying the order is still subsisting now.
Wow. MashaAllah.
The order is still subsisting. It's an order of the court of competent jurisdiction.
Allahu Akbar. Allahu Akbar.
The only time the order will not be acted upon is if the order has been set aside. Either by the same court, or by a court of competent jurisdiction, or a superior court.
Allahu Akbar.
Which is court of appeal or Supreme Court.
Right. Right.
So if anybody is dancing, they are just wasting their time. You know, like I said, if education is expensive, try ignorance.
And that's all free.
And some of them, what I realized they do is that they display their intellectual disability for public ridicule.
Exactly.
Sometimes I watch them, I will just laugh. I will just be laughing. Can you imagine? Sometimes people show some of my colleagues who are classmates, they will say, well, this one, they don't even understand what is going on.
Of course.
Exactly. So that's why I don't mind them. If I come to court, I enter the court, I do my case,
that's it.
I leave.
That's it.
I've been doing cases with senior advocates in ages. This will be the first, this will be the second, this will be the last.
MashaAllah.
So it's a normal thing, it's part of our job. So, but whatever, see, do you know why I won't blame them?
Okay.
It is good for them to give themselves some self happiness. Let them be, you know,
exactly.
Let them interpret it in the way and manner that suits them.
Oh yeah, exactly.
So that they can be able to sleep at night.
Definitely, that's it. That's just it.
So that they can be able to sleep at night. Let them, you know, because but definitely deep down in their heart, they will know that your case will continue.
Wallahi. Allahu Akbar. Jazakumullah. God bless you, sir. Allah bá ndro tin yín o. Allah ní fi yín lẹ̀ o. Allah jàre yín pẹ́ o. Allah ní pa yín kò ní pa wá. Ológun Ọlọ́run. Allah bá gùn yín lẹ́mìí. Àlàáfíà tó péye Ọlọ́run bá ṣe fún yín. La hawla wala quwwata illa billahi al-aliyyil azim. Gbogbo ẹ̀yin tí ẹ wà online, ẹ bá ké lílá fi fún barrister wa fún àlàáfíà ara tó pọ̀ dáadáa nítorí ó fẹ́ tẹ̀ wọ́n díẹ̀ níjọ́ Thursday yẹn gan. Pẹ̀lú bí fẹ́ tẹ̀ wọ́n tó wọ́n ní rárá eléyìí kì í ṣe nǹkan táwọn gbọ́dọ̀ jókòó sílé. Nígbà àwọn ti rí inú àwọn ti róde ẹjọ́ yà wọ́n gbọ́dọ̀ lọ. Ọlọ́run wọlá lílá fi tá máa ń ké fún gbogbo ẹni tí ó bá kù díẹ̀ káàtó fún. Tá bá ké pẹ̀lú Ọlọ́run bá lò yóò bá ń ṣe ìwòsàn tó péye fún yín. Allah bismillahir rahmanir rahim. Ila fi Quraysh, ila fihim rahmatan الله والصيف وليعبدوا رب هذا البيت الذي أتيمهم من جوع وآمنهم من خوف آمين آمين آمين